Okay. I am ready on Harper. This is case number 234491401. The people of the state of Michigan versus Peggy Ann Harper. The defendant is charged with 1 count of gambling, disassociated person. And today is the date set for a pretrial conference. Appearances, please. Oh, hold on. Let me change the settings. Sorry. All right, there you go. Sorry.
Good morning, Your Honor. Alexandra Grimaldi requesting permission to practice under Michigan Court Rule 8.120. I am being supervised today by Assistant Attorney General Alexandra Peterson, and I am a 3L at Wayne State University in good standing.
That's just a great law school. Permission granted. And who are you on behalf of, Ms. Grimaldi?
The people.
All right. Mr. Newman.
Good morning, Your Honor. May it please this honorable court. Attorney David Newman appearing on behalf of the defendant, Peggy Harper, who is present via Zoom. Ms. Harper, please state your name for the record. Also, P number P82515.
Thank you, Mr. Newman. Ms. Harper, please unmute and state your name for the court.
Peggy Ann Harper.
Thank you, Ms. Harper. Today is the date set for pretrial conference. Mr. Newman, how are we proceeding?
Yes, Your Honor. I've had an opportunity to speak with the prosecutor in this matter, and they did offer a delayed sentence under 771.1, which we'd like to avail of that offer at this time, Your Honor.
All right. Ms. Harper, your lawyer has indicated that you want to enter into a guilty plea today with the recommendation from the prosecutor that I received the or sentence you under the delayed sentence statute. Is that what you want to do?
Yes.
Ms. Harper, I'm going to share my screen. When I share my screen, on it will appear an advice of rights form. My question to you, Ms. Harper, is have you had an opportunity to either review for yourself or to go over with your lawyer your constitutional rights? And it is okay if the answer is no.
No.
All right. I'm going to go over these rights with you, Ms. Harper, the relevant rights. I am going to skip over number 1, and I'm going to go down to number 2. Ms. Harper, do you understand that this is a misdemeanor, and therefore you have a right to plead guilty, not guilty, or stand mute? If you stand mute, a plea of not guilty would be entered on your behalf. You have a right to plead no contest with the permission of the court. You also have a right to a trial by jury and the right to the assistance of an attorney. Do you understand?
Yes.
Ms. Harper, you have appeared in court today with a lawyer, so I am going to skip from number 3 and 4, which talks about court-appointed lawyers, and I'm going to go down to number 5. Ms. Harper, do you understand that if you were to have a trial, you would have the following rights: to call witnesses to speak for you at trial? You could get an order from the court requiring witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose to remain silent and not testify on your own behalf, the prosecutor would not be able to comment on your refusal to testify. You also have an absolute right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
Ms. Harper, do you understand that if I accept this voluntary plea from you today, that you are giving up your right to a trial? You won't have a trial of any kind. No witnesses will be called and the prosecutor will not have to prove anything. Do you understand?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this voluntary plea today?
No.
I'm going to skip down to number 8. Are you currently on probation or parole for another case?
No.
I'm going to go to number 9. This is a misdemeanor. It is punishable by, I think, 93 days in jail and up to $500 in fines plus costs. Madam Prosecutor, is this a 93-day misdemeanor?
Let me double check on that, Your Honor.
Okay, because it could be a less misdemeanor based on the charge. But Don't worry about that. I'm gonna get the information for you, Ms. Harper, but I'm not gonna sentence you to jail. I can tell you that. There is no mandatory minimum jail sentence on this case. Additionally, number 10, fines, costs, and other financial obligations owed to the court must be paid at the time of assessment, except when the court allows otherwise and for good cause shown. If you are not able to pay due to a financial hardship, you must notify the court immediately. Do you understand those rights?
Yes.
Ms. Grimaldi, do you have the answer?
Yes, it is a 1-year misdemeanor, Your Honor.
It's a 1-year misdemeanor to go in the casino when you don't supposed to go in the casino?
That it is.
I feel the same.
My good. Oh, now let me say this. I never would have guessed it. I was thinking you were gonna say it's a 30-day misdemeanor.
Yeah, maybe 10 days.
Oh my, okay.
Yeah.
Well, let me go back and just say, again, Ms. Harper, I don't have any intention of putting you in jail. But just for your future knowledge, it is a 1-year misdemeanor. Do you know that assault and battery and domestic violence are 93-day misdemeanors?
Crazy.
Okay, now something has to be done. All right, I digress. It's a 1-year misdemeanor. Okay. Finally, Ms. Harper, I'm going to draw your attention to number 11. It indicates that an appeal to the circuit court may be taken within 21 days of the date of your sentencing or as permitted by law. Do you understand, Ms. Harper, that if I accept this voluntary plea from you today, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would either have to request permission of the circuit court to appeal the conviction or request permission of this court to set aside that plea. Do you understand?
Yes.
All right. With that understanding, do you still want to enter into this plea today?
Yes.
All right. Raise your right hand for me, please, Ms. Harper. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, give me one moment. You could put your hand down. And Ms. Rahal, are you there?
Yes, I am.
All right, Ms. Rahal, I'm going to send you into the breakout room with the defendant. That is breakout room number 18. Okay, I'm going to send you to breakout room number 18, Ms. Rahal.
Okay.
I mean, I said the defendant, but I meant the witness. I meant the witness. Okay.
All right.
Okay, who's going to voir dire Ms. Harper with respect to the factual basis?
I have no
Sorry,
problem with voir diring, Your Honor.
Okay, go ahead, Ms. Grimaldi.
Thank you, Your Honor. Ms. Harper, on January 1st of 2023, were you at the MGM Grand Casino located at 1777 3rd Street in Detroit?
Yes.
And is that in the county of Wayne?
Yes.
And at the time that you were in the casino, were you on the disassociated?
Uh-oh, you went mute. Okay.
I apologize. At the time that you were on the casino, were you registered on the disassociated persons list?
Yes.
The people are satisfied, Your Honor.
One other question I would like to ask before. Did you know that being on the disassociated persons list meant you were not supposed to go into the casinos?
Yes.
Okay. Now, is defense satisfied?
satisfied.
The court is satisfied. I will accept a guilty plea to 1 count of gambling disassociated person that I did not know was a 1-year misdemeanor. Okay, I mean, I think that's horrible, but
That needs to change. I agree.
that's not my business. So the legislature have decided that it's more serious to gamble than it is to assault somebody. That doesn't sound right, but okay, let me stay in my lane and in my business because I am not on the legislature and that is not my business. But maybe somebody could tell the legislatures to watch this video and they could see how kind of off kilter that sounds. And maybe they will either raise the 93-day misdemeanor, but whatever they do with that, they need to lower this one. But nonetheless, again, that's not my business. I'm going to stay in my lane. Is there any objection to immediate sentencing for Ms. Harper?
No, Your Honor.
No objection from the people, Your Honor.
All right. And would the people like to address the court as to sentencing? And Ms. Grimaldi, I would like the people to tell me if you are recommending any length of the delayed sentence period.
Your Honor, we're not recommending a length of the period. We would leave this to your discretion.
Okay. All
Thank you.
right, Mr. Newman, anything?
Yes, Your Honor. Ms. Harper she's 73 years old. She has had a life filled with hardships. I've known her for a little bit of time, but however, the stuff that she shared with me has broke my heart. It's taken me to a point where I've followed up with her. I've wanted to see how she's doing with herself, just because she is such an outstanding woman. In this case, like you said, just entering into a casino has made her feel like a criminal at this time. It is a crime, definitely. She's put herself on that list, and she's not a wealthy woman. She barely has any money, Your Honor. She takes the smart bus around, around town. To get to my office, Your Honor, it takes her a good hour. She has to wake up super early. She doesn't communicate with her family much. She doesn't really have anybody to support her. She's in a very difficult position to even sustain herself sometimes. And I look at her as almost like a hero, how she's doing it day in and day out. She's definitely apologetic for what she did of putting herself on that list and entering into the casino. She's a people person, Your Honor. She loves talking to people. She loves seeing a bunch of people around. After COVID happened, when she was secluded from everybody for so long, she did develop some sort of anxiety and stress, and maybe a little bit of depression, Your Honor, as many Americans did. She definitely wanted to go ahead just to see people. She doesn't have much money to even gamble away, Your Honor. We're asking for non-reporting probation at this time. Like I said, she doesn't have any prior convictions. She's a stand-up person. She's very responsible. Like I said, she even to come into our office, she comes at 6 a.m. sometimes. Miss Harper she's a good woman, Your Honor, and I can say that with full confidence.
All right, Ms. Harper, would you like to say anything to the court before I impose your sentence?
No.
All right. Yeah, I can't even imagine that this is a one-year misdemeanor. Now, let me say this. I do understand why it's a crime. Initially, I didn't understand why it's a crime, but I do understand why they have criminalized going into the casino if you're on the disassociated persons list. I am thankful that the legislation changed right after I was assigned to this docket, or sometimes shortly after, within a year, maybe even shorter than a year, maybe 6 to 8 months after I got assigned to the docket. When I first got on the docket, the disassociated persons list was a permanent thing. Once you put yourself on it, you couldn't take yourself off. And I used to say on every case that I thought that was horrible. Now, I don't know if the legislatures listened to me. It may not. They probably didn't. I don't know. I'm not a lobbyist or anything of the sort. But within 6 to 8 months, the law had changed, and the person can at least take their name off of the disassociated persons list. So that was at least good. But I understand, for the good of the community, that if a person identifies themselves as having a gambling problem, then it is incumbent upon the government to some extent to protect society from things such as individuals who would gamble so much their addiction may take them over, and then now you're starting to rob me, or trying to get money to gamble. And that's how identity theft and those type of things can develop from an individual who is addicted to gambling. So I understand why it's criminalized. Now, I don't understand why it's a one-year misdemeanor, but I understand that. A person can also have their name now removed from the list after 5 years. And so, Ms. Harper, if you know, the things that your lawyer said about you having limited means and this, that, and the other, that really means, you know, you have to not gamble it away. Now, if there was a list for Lay's potato chips that I put my name on, you know, I would probably be sitting in court too, because or either I would have to not shop for myself. I'll have to try to not shop for myself. Because if you go in the store, and like the other day when I went in the store and then Lay's had buy two, get two free. I mean, it was just a shame. You know, that the price of the chips already too high. So they raised the price of the little family bag or the big bag to $4. It's not $4 worth of potato chips in there. So when you tell me I could get 4 for buy two, get two free, I'm going to buy them, right? And I did. And unfortunately, I've been eating them. So I understand not having some sort of, you know, self-control over the thing that you know is bad for you. But you're going to have to try, Ms. Harper. You're going to have to try. So this is what I'm going to do. I am going to sentence you pursuant to the delayed sentence statute for 6 months. That means that if you do what I asked you to do, after 3 months, you can actually get off probation. So the probation is 6 months, but if you complete the terms and conditions after 3 months, you can get off. I'm going to impose the mandatory cost of $210. And then with respect to the remaining cost, it is a non-reporting probation. However, it is a non-reporting probation, but I do need Ms. Harper's address and phone number. And we're going to have to connect her with Ms. Green, because I am going to order community service in place of those other fines, costs and fees. So I'm going to impose 5 days, which is 40 hours, which is equivalent to $400. So that's how it goes. 5 days of community service, which is equivalent to 40 hours, which is equivalent to $400. I am also going to order gamblers counseling. And then she may need a referral. So I don't know if she can go anywhere for the gamblers counseling. So like it doesn't have to go through probation, but it has to be a person, you know, a doctor, a licensed counselor. And then she's going to go once a month to the gamblers counseling. Is she eligible to have her name removed from the disassociated persons list? Has she been on the list for 5 years?
I am checking the date of signature. She's been on since 2017. So yeah.
So yes, so she is eligible to have her name removed. So if you feel like you no longer have a problem, then you can petition to get your name removed. I don't know all the requirements. I am also going to say though, notwithstanding, if you get your name removed within this 6 months, you can't have any contact with the casinos within the 6 months. So no contact with the casinos within the 6 months. If Mr. Newman, your client does need a referral to a gambler's counseling, I don't know what her medical insurance or whatever information may be. So we may have to connect her to the 1-800 number from the court. So if that is the case, let us know and we will get that referral. Please call my courtroom, Mr. Newman, and make sure Mr. Flanagan has Ms. Harper's current address and phone number so that we can mail her a copy of the order of dismissal. Didn't mean it, sorry, prosecutor, not dismissal, the order of probation. Also, I'm sorry, as a condition of her probation, of course, you cannot get any new offenses. No new cases. And then Mr. Flanagan, make sure we put this on a delayed sentence form. And then no driving without a valid license. Well, you told me she catches the bus anyway. And I think those are all the conditions that I'm gonna set. Anything further?
Your Honor, can I get that number?
965, I'm sorry, 965-2295. 965-2295.
Okay, and then we'll get that information from there.
Yes.
I believe that's it. yeah. The only thing is with that gamblers counseling.
Mhm.
Yeah, I don't know exactly how that works. Yeah. So for her,
It depends.
yeah.
So some of them, they do it in person, some of them do it online.
Okay.
So I don't know what her situation, it looks like she's in your office though, right now. Is she in your
Yes.
office?
Yes.
So she may not have the ability to do it virtually.
Okay.
So they can definitely find something for her close to her home.
Okay.
And that's with the community service also. So it's not going to be a situation where she's going to have to go far and all of that. So maybe that's why I'm going to make it where she can report to probation on the initial occasion. So report to probation. They will contact her for, I'm going to say report to probation for referrals. And then they will find a place, the community service, they'll give her close to her home. It's the holiday season. So, it could be like a, what do you call it? The people that ring the bell, like Salvation Army, and those might be like close to her where she could go, but they'll work with her based on her address.
Okay. And you said 5 days, 40 hours. So she has to, are you saying she has to complete the 40 hours within 5 days?
No, I'm saying I'm giving her 5 days of community service, which is equivalent to 40 hours. So like if she go one day and only work 3 hours, that's not enough. You know what I'm saying? Like it doesn't count for 5 days. It's 40 hours. She can do the 40 hours through the course of the whole 6 months.
Okay. Okay.
Yeah. Okay. All right, then you can call the courtroom, give us that address and phone number, and then we'll mail this out and probation will contact her, okay?
Okay. Thank you so much, Your Honor.
All right, you're so welcome. Have a great day and stay safe.
Thank you. You too. And happy
All right.
holidays. Thank you.
Same to you.
Thank you.
All right, and to the people also, happy holidays and have a great day. Stay safe.
Thank you.
Your
You
Honor.
too.
Hi, Mr. Elder.
Good morning, Judge. How are you?
Wonderful, thank you. I'm ready, but the prosecutor is talking to a witness and let's see, with an interpreter. So when he finishes, then I'm gonna take one case in front of yours and then I'll be ready. And then you're representing both defendants, right?
That's correct, Judge.
And one of them is in person, but the other one is on screen. And also the interpreter is on screen. So you didn't need, right, you didn't need the interpreter to assist you in speaking with your client though.
Judge, I thought there would be a resolution today, but Judge, I think that we're gonna probably need some other day, and I may want the interpreter, just for the legal language.
Say that again. You say that again, Mr. Elder. You may want the interpreter to talk with you and your client in private, or are you just saying on screen?
Judge, a later date I may need it. So today, I don't think.
Okay, yes. Oh, yeah. But the interpreter is here today. But yes, I'll make sure they order an interpreter for each hearing.
Thank you, Judge.
Okay, you're welcome. All right. Well, we're kind of on a recess until Mr. Henderson comes back out, but I'm going to bring Miss Sadie and Mr. Staunton. So I'm going to take that one case first, and then I'll be ready for you, Mr. Elder.
Absolutely, Judge.
All right. Miss Sadie, I'm still waiting on the prosecutor to come out. I'm going to help him along a little bit. Mr. Flanagan, do you have a cell phone number for Mr. Henderson?
I do not, Your Honor.
Me either. Okay, so I'm going to have to go into the breakout room and tell him to come out. All right. So I'll give him another couple of minutes and then I'll go in and grab him so we can get you two on your way.
Thank you.
You're welcome. Mr. Stoughton, we're gonna be ready for you in a moment.
Okay, Your Honor.
Okay, he's talking, and so he doesn't see my message that I sent him. Mr. Flanagan. Oh, never mind, hold on.
Yes, Your Honor.
Never mind. All right, thank you, Mr. Henderson. Okay, Ms. Sadie, I'm ready on Stoughton, and then I'm ready on Al-Malahi and Malahi. All right, this is case number 22-447-60001, the people of the state of Michigan versus Brent Michael Stoughton. The defendant is charged with 2 counts of assault or assault and battery. Today is the date set for final pretrial conference appearances, please.
Good morning, Your Honor. Philip Henderson on behalf of the people, P86029.
Good morning,
hold-
Your Honor. Nicole Sadi, P74238. I represent Mr. Stoughton, who's present via Zoom without objection.
And Mr. Stoughton, please unmute yourself, sir, and tell the court your name.
Brent Michael Stoughton.
Thank you, sir. Stoughton with the long O, Stoughton. Thank
Yes,
you.
Your Honor.
Okay, today is the date set for, it says final pretrial conference. And Ms. Sadie, off the record, you had indicated that I had set this date for some discovery issue. Can you place that on the record for me?
Yes, I believe we were going to visit the discovery order you issued the last time and deal with that today.
Yeah, I think, so the first time you were here, was it? No, Mr. Flanagan said it was a pretrial. All right, Mr. Henderson, do you have any, so I strike that, I'm sorry. So Ms. Sadie, did you not receive discovery? Is that what you're saying?
I did not. I
Okay.
did not. And yeah,
Mr. Henderson, do you have any records? Are you able to see in your system whether Ms. Ritter sent discovery?
So the case is, it shows in our system that discovery was sent on August 30th and then again on October 9th. It has it, the case was assigned on October 9th, so I believe that's when it would have, well, pardon me. The first defense attorney appearance that we have in our system is on August 22nd. So it's shown that it was sent both times after Ms. Sadi had been assigned. That's for the paper. I can resend
Well, I
that
don't,
now. If it's-
well, it sounds like it was sent twice. So do you have in your system what email address it was sent to?
I have paper.
Oh, you have
I do have the paper.
Okay,
Yes.
so, okay, you have paper. And so this is 2 counts of assault and battery. What other discovery is there?
So there were 2 statements made by the complainants that should have been recorded on December 31st, 2020. There were statements
Were they
allegedly
recorded
made by
or were they just written? Or do you,
I have. Okay,
do
so
you
there
have
are
the
ones
written, do you have the written statement from those witnesses?
from complainants. I have written statements. There
Okay.
is in written discovery, it states that there were recordings made, a DVD of
Oh, okay.
my client being interrogated and another witness, an alleged driver, being interrogated. I haven't received those. It specifically does state they were recorded. I haven't received a statement as to whether or not this MSP trooper had his body camera activated. It was MSP Trooper Lehman, where he went out to Fairlane Mall on December 21st, 2020 to talk to complainants.
I can tell you that he didn't, because unless something has changed, the state troopers don't have body cameras. They have dash cameras.
So what I learned is they get them post by post, but they didn't get them all at the same time.
Okay, oh, thank you. That's that's okay. That's information that I didn't know. So maybe I'll have to now inquire with respect to that, if that particular trooper has body cam based on their assignment. That's what you're saying. Some posts do have body cameras.
Yes, I learned that. I thought they all did. I was on the other end of
Oh.
your thinking. Then I learned through experience recently, they receive them post by post. Not all of them received body cams at the same time.
Right. Yeah. So I knew that they didn't have them back from my days. Oh, how did that? Back from my days on exams. Okay. So, Mr. Henderson, is there any information in your system regarding the digital discovery, the videos of those interviews, and an inquiry as to whether this particular state trooper post has body cam?
So, Your Honor, I've checked the notes that are in our system. Okay, first of all, I've checked evidence.com, which is where all digital discovery is logged. According to the case report number, which is what should be under, it's not there. I don't have any notes regarding whether OIC was emailed or contacted requesting it. Which is my standard practice when I receive a discovery order, but this isn't my normal courtroom, so I don't have any indication that it was requested or inquired about. It could have been, but I don't have any
Yeah.
record.
I know. Okay. And I just from experience, I think that's Miss Ritter's practice too. However, she's not here, and she's not on vacation. Unfortunately, she is sick. Okay. All right. What I'm going to do is adjourn the final pretrial conference. I don't know if Miss Ritter did request it from the OIC. I hope she did. But if she didn't, I suppose she's going to have between now and the adjourned date to do so. But so specifically, Miss Sadie is saying that there were at least 2 witnesses. And did you say your client as well, Miss Sadie?
Yes, there's the 2 complainants. That's the inquiry as to the body worn camera. And then there is a written statement saying there's a DVD recording made of my client's interrogation and another alleged witness that was in the car at the time.
Though that sounds like maybe 4 potential videos. And
Yes.
I need her to have those if they exist. And if so I need her to have those 4 videos. So let me write this down. Okay, so Mr. Henderson is gonna leave a detailed note from Ms. Ritter. And he may, I don't want to confuse the OIC and then they send it to Mr. Henderson instead, but by next week, there's going to be some inquiry to the OIC regarding those 4 videos. So defendant has paper discovery, but she's in need of video discovery, and we don't know if Ms. Ritter already requested it because she's not here. I'm going to adjourn this to Wednesday, February 7th. I'm sorry, Mr. Flanagan, am I? Hold on.
Yes, Your Honor, just 6 that day.
Okay, great. All right, I'm going to adjourn this to February 7th. If that's a good day for you, Ms. Sadie.
Yes, thank you, Judge.
All right, at 9 o'clock. And we definitely want some headway with the video discovery. So she does have a right to it. Also, if it does not exist, if they don't have body cam, if they like the 2 of them, she said it's an inquiry as to the body cam. So if they don't have body cam, I need that in writing then. So I wasn't aware that some posts have body cam and some don't. So if this is a post that doesn't have body cam, then just put a note for Ms. Ritter that I want to like something from the OIC or whatever that says that post doesn't have body cam capability. Because I didn't think any of them had it, but I guess I'll have to look into that a little further. All right, and then the 2 videos, DVDs though, those should be available.
Yes, sir.
DVDs, there shouldn't be a reason that they are not available. All right, anything further?
Not for Mr. Stoughton, thank you.
No, Your
Okay.
Honor.
All right. Then Mr. Stoughton, we're all set. Have a great day. Stay safe. Happy holidays to you both.
Thank you, Your Honor. You too. Happy
All
holidays.
right.
Thanks.
you.
Happy holidays.
Thank you. All right, Mr. Elder, I'm ready. Let me I have now another interpreter too. Oh, maybe the other interpreter had to go. Okay, let's see. Let me see. Let me see. Good morning, Ms. Gannell.
Good morning, Your Honor. How are you today?
I'm wonderful. Thank you. How are you?
Good. Thank you for asking. I'm subbing for my colleague. He
That's
had
what
the
I was going to ask you. Okay, on Malahi?
Yes.
Okay, because I'm like, now I have another interpreter. Okay, great.
Yeah.
Okay.
Yes.
Okay, so then let me bring in Mr. Al-Malahi, and then, but well, it doesn't matter at this point which defendant needs the interpretation because she's going to interpret.
Yes.
And so, but for future, Mr. Elder, the interpreter, okay, now he's not connected. Oh, come on, Mr. Al-Malahi. The interpreter is specifically needed though for Malahi, not Mr. Al-Malahi, right?
That's correct, Judge.
Okay, all right. Let me see if I can get Mr. Al-Malahi connected. I'm going to share my screen. He's
Your
not
Honor,
connected. We might end up waiving his presence. Yes?
sorry, just as a point of logistical procedure, so we have an interpreter for a defendant and an interpreter for a complaining witness on the same case, right?
Is that witness on? That's the
Yes.
witness on this case?
Yes, Your Honor.
Oh, well, no, that's not going to work. So I don't need both. Oh, well, maybe I do. Okay. Yes, we do. So were you still talking to the witness?
Yes, Your Honor.
Oh, okay. Well, then go ahead and finish that up. And then, yes, I'm going to have to figure out logistics, but that's going to be interesting. Okay. Yes.
So if it's going to be on Zoom, they're gonna hear what I'm saying anyway. It's different than being in court when we
Right.
do simultaneous.
Oh, he left. Okay, but what I probably will do is I'm going to let you interpret since you are the interpreter for the defendant. And then I guess I did need the interpreter because he needs the interpreter in the breakout room, and that's what they're doing. And then I guess if there's anything specific that we direct to the witness, then I'll have Ms. Rahal interpret that. So that's how I'm going to do that. Okay.
Oh,
All right, well, then
originally you
give us-
had two interpreters, right, Your Honor?
Yes, I have.
Originally? Okay.
Yeah, I had two interpreters because the
Okay.
witness needs an interpreter. But since we're on Zoom, the witness is going to hear what you're saying when you interpret.
Okay, is Ms. Rahal still here? Because
Yeah,
I'm
she's
just.
in the-
having-
She's in
oh,
the breakout room.
okay.
She's in the breakout room with the witness. Oh, so let me ask you this. No, you were
I'm
filling in for the other interpreter, right?
Yes, yes,
Okay,
only,
yes.
yes,
Mhm.
because he had problem. He got disconnected and he doesn't have internet at his home. I don't know if there is a branch or something. He has technical difficulties. He called me on the
okay.
phone. Can you stop for me? Like the judge is waiting. I said, yeah,
Oh,
sure.
Okay,
So-
yes. So I've always had two interpreters.
Oh, okay.
Yeah.
So Ms. Rahal can interpret and I interpret for the defendant. But but if you're gonna ask the witness, he can hear her, so we're not gonna double interpret.
Well, you're interpreting for the defendant. She's interpreting for the witness.
Okay.
But we'll do it. We'll figure it out. There's only going to be one interpreter at a time. I know that.
Yes. Yes.
Okay. Well, then, as soon as he comes out, then we'll be ready. So I'm sorry, Mr. Elder, I'm not quite ready. Let's let him. All right. Okay, so everybody just hold tight for a minute. Let me see that last. Andre Paul. Oh. Okay. Oh, and then Mr. Flanagan, I still didn't put the review dates on the record after I saw your message. Sorry. So let me give them to you and then maybe we can call the lawyer. So her first review date is March 14th.
Okay.
And her second one is June 13th.
Okay, the attorney just called, so I'll just call him back right now and let him know.
Yeah, I forgot to put it on the record even after I saw your message. Thank you. All right, well, we're kind of on break until Mr. Henderson comes back out, and that'll just be a couple of minutes. Okay, the witness didn't come out though. Let me try to bring him out. And then apparently, so I have two interpreters, one for the witness and one for the defendant. So what I'm going to do is I'm going to just let Ms. Ganem, who is interpreting for Mr. Malahi, I'm going to let her interpret, and then whenever we direct something to the witness, then I'll let Ms. Rahal interpret, okay?
Okay.
All right, but both interpreters, and let me get Mr. Oh, tell me he did not leave. Oh, no, there he is. Okay, let me get the other defendant. But I'm gonna swear in both interpreters. So Ms. Ganem, state your name for the record.
Good morning, Your Honor, Tanya Ganem.
And Ms. Rahal, state your name for the record.
Good morning, Your Honor. Samara Rahal, interpreting Arabic for the court, state certified qualified.
All right, and ladies, raise your right hands. All right, do you both swear or affirm that you would translate from English into Arabic? And Ms. Ganem, anything with respect to Mr. Malahi from Arabic into English, and then Ms. Rahal as it relates to Mr. Qzzn6c0 when directed by the court, to the best of your ability and according with the law.
I do.
All right, thank you. Okay, so Ms. Ganem, you're going to interpret unless I ask Ms. Rahal, okay?
Okay.
All right, this is case number 224537501, the people versus Ghazi Malahi.
هاي القضية 2245355001 الولاية ضد غازي ملاهي.
And 02 Ahmed Abdullah al-Malahi.
و02 أحمد الملاهي.
And each defendant is charged with one count of assault or assault and battery.
وكل مدعي عليه متهم باعتداء أو اعتداء مع الضرب.
And today is the day set for final pretrial conference.
واليوم آخر جلسة ما قبل المحكمة النهائية.
Appearances, please.
كل واحد رح يعرف عن نفسه.
Philip Henderson on behalf of the people, P86029.
فيليب أندرسون عم بيعرف عن نفسه، هو المحامي تبع المدعي العام.
Good morning, Your Honor. Durade Elder, on behalf of Mr. Ghazi Malahi and Ahmed al-Malahi.
دوريد ألدر المحامي تبع غازي وأحمد الملاحي.
Okay, and then Ms. Rahal, can you ask Mr. Qzzn6c0 to state his name for the record?
سيد أعطينا اسمك الكامل.
محمد علي قاسم.
All right, and then Ms. Ganem, can you ask Mr. Malahi, Ghazi Malahi, to state his name for the court?
أستاذ غازي ملاحي، عمول معروف، قول اسمك.
My name is Ghazi Malahi.
And then Mr. al-Malahi, state your name for the court, sir.
أستاذ الملاحي، قول اسمك.
أحمد الملاحي.
أحمد الملاحي.
All right. Today is the day set for final pretrial conference as to both defendants. Mr. Elder, how are we proceeding?
يعني اليوم آخر جلسة ما قبل المحكمة، فأستاذ ألدر كيف رح نكفي؟
Your Honor, if the court recalls, the last time we were in court, the court wanted us to engage in community mediation.
يعني آخر مرة وقت كنا موجودين بالمحكمة كانوا بدهم يسووا جلسة اتفاقية second, Your Honor.
Did you hear what he said? Community mediation?
Yes, جلسة وساطة.
Okay.
Because Mr. Ghazi Malahi lives literally 10 feet to maybe 10 yards away from Mr. Muhammad Qzzn6c0.
لأنه أستاذ غازي يعني عايش 10 يارد أو 10 أقدام بعيد من أستاذ قاسم محمد قاسم.
Yeah, it's my understanding that the last offer was for a delayed sentence from Ms. Ritter.
يعني آخر مرة إنه وقت اللي عملناها إنه بدنا نسوي جلسة مؤخرة بهذه القضية.
However, Judge, somehow some sort of miscommunication occurred. Your Honor, we did not receive notice or contact from neighborhood mediation whatsoever.
يعني آخر مرة ما وصلنا أي إنذار أو أي شيء بالنسبة لجلسة اجتماع الوساطة.
I'm not sure if that's from my end, Your Honor, or that's from their end.
فما بعرف إذا هي من جهتي أو من جهتكم.
So, Judge, I would like to at least give that an opportunity. That way, we're not here, Judge, for violations of any sort, if we have a resolution.
فمشان هيك إذا في أي يعني ما بدي يصير في أي مخالفة أو أي شيء بهيدي القضية فمن جهتنا أو من غير جهة.
Okay, this case. Mr. Flanagan, what's the trial date for this case?
اسأل شو هو التاريخ تبع المحكمة بهيدي القضية.
March 11th, Your Honor.
شهر 3 يوم 11.
Mr. Flanagan, what is the okay, go to March 11th. What happened with the Smith case? The final pretrial was November the 15th.
عم تسأل would you like me to interpret that, Your Honor?
You don't have to, no.
Okay.
It was scheduled for another final pretrial for February 20th at 9 a.m.
And then what about Zoriana? When is the final pretrial?
That's not on the schedule for March 11th anymore.
Oh, that's her last name, Harris. Okay, it's not?
Harris, okay, I see. Final pretrial, January 11th.
Okay, and then what about Perkins, Felicia?
Final pretrial, March the 1st.
Okay. Okay, now you can start back interpreting, Ms. Gannon. Mr. Elder, I did have your case as my first in priority case for the March 11th jury trial date.
أستاذ ألدر يعني حاطة أولوية للقضية تبعك بشهر 3 يوم 11.
What I will do is I will keep that jury trial date, but I can make it, I do have other cases scheduled that day.
يعني رح كفي إنه محكمة يحكموا فيها الحلافين بس عندي غير قضايا رح خليهم.
But I would like to schedule another final pretrial conference and yeah, I don't know what happened with the mediation, but we can try to contact them to make sure that something is scheduled before that jury trial date.
يعني رح خلي التاريخ تبع المحكمة اللي يحكموا فيها الحلافين، بس ما بعرف شو صار بالنسبة لجلسة الوساطة. ف يعني بنشوف لحتى تصير بركة قبل هيدا التاريخ.
However, let me inquire of the prosecutor. Mr. Henderson, is your client's, not your client, I apologize. Is your witness still interested in mediation? Ms. Rahal, you interpret that.
بدها تعرف القاضي السيد إذا أنت بعدك لك خاطر يكون في مكان متواسطة بخصوص قضيتك.
Your Honor, pardon me, but we didn't discuss that when we were in the breakout room, so I'm not sure.
Pause. Ms. Rahal.
قال ما تحدثنا مع السيد هندرسون عم بيقول إنه ما سألك هالسؤال لما كنا بالغرفة.
Okay. Mr. Kassim, are you interested in going to mediation where you could have some how do I describe it? A third party try to come up with a resolution between you and the defendants. Are you interested in that?
سيد قاسم بتريد يكون في شخص ثالث يكون متواسط بينك وبين اللي دفع عليهم قضية، بينك وبين أحمد ومحمد or
No, I'm sorry.
No.
Okay.
I'm so sorry.
You don't have to apologize. He's not interested, Mr. Elder, and I can't make him, and they're not going to schedule it if both parties don't agree.
Understandable, Judge. So if we could just set this for maybe one more final pre-trial so I can discuss it with Ms. Ritter and see if we can reach a resolution.
Ms. Gannon.
عم بيقول انه القاضي قالت له استاذ ألدر انه ما بهم ما يريد اجتماع الوساطة، فاستاذ ألدر عم بيقول له مش مشكلة، من نعمل جلسة بعد اخر وحدة تبع المحكمة البدائية، نعمل بعد جلسة.
Okay.
ليكون
the hair is Ms. Stevenson on here? Ms. Stevenson? Do you have any information on the Zorina Harris trial that's scheduled for March 11th, but your final pretrial is January the January 11th?
I don't right now, Judge.
Okay. Mr. Elder, is January 11th too soon for you to talk to Ms. Ritter?
Judge, if we can have.
عم تسأل أستاذ ألدر إذا شهر واحد يوم 11 بكير هيدا التاريخ.
Well, what I'll do is, Ms. Elder, don't worry. I'm going to set you for February 20th. Are you available for February 20th?
شهر 2 يوم 22 عم تسأل أستاذ ألدر إذا موجود بهيدا التاريخ.
Can we have the week before? I might be in a federal trial on that day if it goes.
Your Honor, the matter I have for the 11th of March is less likely to go. That has a low likelihood.
Okay. Mr. Elder, the week before I'm sorry, the week before February 20th?
Yes.
Okay, so the week before is That would be like Valentine's Day. You want that day or the 15th? You want 14th?
Any week besides that 1 week of the 19th, Judge. So it could be the 12th or the 5th, doesn't matter to you.
All right. Let's schedule the final pretrial conference. Let's do Thursday, February 15th.
رح يعملوا التاريخ هو شهر 2 يوم 15
at 9:10.
الساعة 9:10.
And then I do still need 2 interpreters, Mr. Flanagan.
Yes, Your Honor.
Okay. And then Ms. Rahal, this is for you. Mr. Qasim, you don't have to come on February 15th. However, if you want to know whether the trial is going to go on March 11th, then it's probably a good idea for you to come.
سيد قاسم ما ضروري تحضر على جلسة شهر 2 يوم 15 ولكن إذا بدك تعرف إذا رح تكمل القضية بيكون أحسن إذا حضرت شهر 2 يوم 15.
If you don't come, then you need to get in touch with the prosecutor's office to find out if you are needed on March 11th for the trial.
ولكن إذا ما جيت شهر 2 يوم 15 اتصل بمدعي العام لتشوف شو رح يحصل بخصوص قضيتك.
اوكي اذا اقدر اجي يعني وين الزوم يرسلوا لي الزوم اريد احضر.
I really want to be on Zoom that day.
Yes, you can be on Zoom February the 15th.
شهر 2 يوم 15.
Thank you.
Okay, anything further with respect to this matter?
Yes, Your Honor, I believe there's something we need to take up.
في شيء بريد لك يا القاضي. Go ahead.
Your Honor, I appreciate the court's patience with my conversation with Mr. Qasim in the breakout room. The reason it took so long is there's been some serious allegations of violation of the court's no contact order. I didn't give notice or file a motion for a hearing or anything, but I would like the court to.
Ms. Rahal.
سيد حضرة القاضي بريد أقول لك إنه في أشياء بالنسبة لمخالفة القضية جدية بريد أقول لك عنه.
Okay, I'm going to end. So, okay, Mr. Henderson, but what I'm going to do based on your notice to the court.
اللي رح أعمله سيد هندرسون بالنسبة لإنذار كلامك للمحكمة
Mr. Elder, are you available Tuesday, December 19th in the afternoon for a bond hearing?
تسأل أستاذ ألدر إذا موجود بشهر 12 يوم 19 لتسوي جلسة الكفالة.
Judge, would the 20th work by any chance?
Nope, hold on, because I'm covering exams that day. Hold on, let me look at the document. Actually, it may work. Let's put it on for the 20th. Well, hold on. Ms. Stevenson, Mr. Flanagan.
Yes, Your Honor.
Yes, Your Honor.
Okay, is Ms. Stevenson, are you the attorney for Anika Washington? On
I am,
December?
Your Honor.
Is that
I
going?
am.
Is that going?
I don't think so.
Okay. All right, Mr. Elder, I can do it December 20th at 1:30.
Judge, it will be live, correct?
It will be live, Ms. Rahal, this is for you. Mr. Kassem, I am going to address your issues or whatever issues you raised with the prosecutor about the bond conditions being violated in person on December 20th.
سيد قاسم أنا رح أتكلم بالشهر 12 يوم 20 1:30 بعد الظهر بالنسبة للمخالفة اللي بتدعي أنتو المخالفات الكفالة.
1:30 in courtroom 339, December 20th.
بدك تحضر 3 9 شهر 12 يوم 20 الساعة 1:30 بعد الظهر شخصيا.
لو سمحتي ممكن تعيدي لي التاريخ؟
Would you repeat that date? شهر 12 يوم 20 الساعة 1:30 بعد الظهر.
وين أحضر؟
غرفة 339.
بالمحكمة يعني؟
So live in court, yes. نعم.
Yes.
نعم.
Okay, so I'm not going to address it today. What I am going to say, Ms. Ganem, this is for you to interpret.
Yes.
So what I am going to say is, I know you all are neighbors, but just almost stay in the house until the 20th.
يعني بعرف انكم جيران بس كل واحد يضله ببيته لا شهر لا 20 الشهر.
I'm going to hear what the allegations are, Mr. Henderson. I need Mr. Elder to be made aware of what the allegations are. And then I'll have to decide how reasonable, you know, I might have to alter my bond conditions, but we'll address it on December 20th next week.
Thank you, Judge. Mr. Henderson, I'll be calling you to find out what the allegations are.
All right. Yes, sir. Thank you.
Do you need Mr. Henderson's phone number?
Judge, I have it as the number I have is 202-7074. Is that correct?
That is correct.
Okay, I called it yesterday as well. So, okay, thank you.
Okay. All right, December 20th at 1:30. Bond
Thank you, Judge.
hearing. You're welcome.
Thank you,
Your Honor.
All right, thank you. Have a great day. Stay safe.
You
Thank
too.
you.
All right.
Bye-bye.
Okay, I might need just a short break, but we'll see. Okay. Whoops.
Mr. Kassem, you can log off.
Go out.
Yes, sir.
Excuse me, can you give me your number? Or you can?
Me?
Yeah.
Yes. 313-202-7074.
Right?
Yes.
Thank you so much.
Okay, thank you, sir. Masalam.
You speak Arabic because of how he gonna talk to you? You
I
do
just,
a little bit. Y'all got a lot of talents that I don't have, Miss Deepson and all y'all. Okay, well, don't worry. All right, let's try to get a little bit of other work done. Those took a little while. No problem though. Let's see here. Let me see what I can do quickly to get some people out. Where's my docket? Oh, here it is. Okay. All right, let's see. Do I have any? Oh, yes, Mr. Henderson, your witness is still in that breakout room. Let's move her. Let's see if she'll move. So I'm gonna do Jenkins because there's a complainant here. Let's do Jenkins. I don't, oh, there's you, Jenkins. All right, I'll bring in. Oh, yeah. Thank you for the reminder. Thank you, Mr. Henderson, you have another witness. I'm gonna bring them in. You haven't talked to them, but let me see if the defendant is here. Let me check the chat again. I have a great clerk. Did you all know that? He's
Yes, that.
So this is on Knight, and let's see. Oh yeah, so Knight is also here. So this, there's the witness is on Knight, Estrada Jimenez. That's the witness on Knight. I'm gonna rename them. Did you need to speak with them, Mr. Henderson?
I spoke with them yesterday. As I
Oh, okay.
understand, they have to appear, so that's what I told them.
Okay, well then we'll do them after I do Jenkins. All right, I'm ready on Jenkins. This is case number 234481601, the People versus Eugene Anthony Jenkins. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for final pretrial conference. Appearances, please.
Philip Henderson on behalf of the people, P86029.
May it please the court, Abdullah Mugni here on behalf of Eugene Jenkins, who appears today via Zoom. Eugene, could you please unmute yourself and say your name for the record?
Mr. Jenkins, you should have seen a prompt come up on your screen to unmute, sir. Please unmute. Come on, Mr. Jenkins. Mr. Jenkins, come on. Look at the screen. Look at the screen.
Okay, there we go. We got it.
Okay, there we
Unmute.
go.
Can you hear me?
Yes, sir, we can.
Please say your name.
Eugene Anthony Jenkins.
All right, and then Miss Gaddy, unmute and state your name.
Dolores Gaddy.
Thank you. Today is the day set for final pretrial conference and the complaining witness is present. Mr. Mugni, how are we proceeding?
Because the complaining witness has appeared, we're going to ask that this matter be set for a jury trial and that any evidence that has not already been sent, please be sent over to us.
Court is going to continue a not guilty plea on behalf of Mr. Jenkins, and I will set the matter for jury trial. Court will set a jury trial date for July 15th.
July 15th, what time? I mean,
Hold on, sir. Sir, don't do that. Just let me finish talking, okay?
All right.
Certainly, I wouldn't do that. Okay. All right, the court sets the jury trial for July 15, 2024 at 10:30 a.m. I will set a final pretrial conference. Mr. Flanagan, what is the date of Mr. Leonard Felton's final pretrial conference? Mr. Flanagan?
Yes, the final pretrial, June 17th.
All right. So I'm going to set a final pretrial conference for Mr. Jenkins, also for June 17th. (2024). That final pretrial conference is at 9 o'clock. Ms. Gaddy, if you could come back and screen, please. All right, ma'am, you have appeared today. Your appearance is not required on June 17th. However, on June 17th is the date that we will know for sure whether the July 15th trial is going to go. So you can appear that day, or you can make sure you contact the prosecutor's office to find out if the trial is going to go July the 15th. So the next court date is June 17th at 9 o'clock. Strike that, put it 9:10, of course. That'll be at 9:10, I'm sorry. All right, bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
No, Your Honor.
All right, then we are all set until June 17th. Everyone have a great day, stay safe, and happy holidays.
Thank you. You have a happy holiday too, and Merry Christmas and Happy New Year.
All right, that's included in them holidays, Mr. Jenkins, but thank you.
You're welcome. Thank you.
All right, I'm ready on night. Mr. Alfredo Estrada Jimenez, can you please start your video? Whoops. And oh, Ms. Stevenson, there's no plus, Mr. Mooney, there's no plus sign by night.
I'm here.
You all talk tonight?
Yeah, I spoke with.
Okay.
That's my mistake.
Oh, he's not connected though. He must have left and came back maybe. All right, let me share my screen and see if I can get him on. Do we have a phone number for Mr. Knight?
Yes.
Maybe you can call him and draw his attention to his device.
Sure.
All right. While we're waiting on that, I'm going to go ahead and do a couple other cases. Are we ready on Boyce?
Yeah.
And Burnett. Hold tight, Mr. Estrada. Oh, there's Mr. Of course, when I bring somebody else in. Of course. Oh, it always works. Mr. Knight, please start your camera. Okay, he's still not starting his camera. I'm ready on Boyce. This is case number 234546901, the people of the state of Michigan versus Ashley Carolyn Boyce. The defendant is charged with 1 count of assault or assault and battery, and today is the date set for pretrial conference. Appearances, please.
Philip Henderson on behalf of the people, P86029.
May it please the court, Abdullah Mugni here on behalf of Ashley Boyce, who appears today via Zoom. Ashley, could you please unmute your mic and say your name for the record?
Ashley Boyce.
Today is the date set. What's your middle name? I'm sorry.
Ashley Carolyn Boyce.
Today is the date set for pretrial conference. How are we proceeding?
So, Your Honor, it does not appear that the complaining witness, Samantha Bronkowski, is present today. If that is true, we'd like to move for a dismissal based on her failure to appear.
Mr. Henderson.
In Your Honor, the people would request an adjournment to allow her to appear.
Today is the date set for pretrial conference. It is the first scheduling of the pretrial conference. The court is going to deny defense counsel's motion for dismissal. I will grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I am going to set a pretrial conference for January the 25th, I believe. Mr. Flanagan, how many do I have that day?
'28.
Okay, we're gonna move to a different day. What about February the 1st?
'26.
And what about February 2nd?
'18.
Court is going to set the matter for February 2nd. At 8:36, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thanks, Your Honor.
Your Honor, just to clarify, did you say February the 2nd? Did I get that right?
I did, yes.
Okay, thank you, Your Honor. Nothing further from the people.
All right, and then we are all set, Ms. Boyce, until February 2nd. Have a great day and stay safe. And happy holidays to you. Was Mr. Knight having problems with his camera? Okay. Oh, yeah, this is, yes, this Mr. Knight who keep on walking around, who keep on not sitting still, who keep on not being ready to attend court. Oh, yes, this is Mr. Knight. I'm ready on Burnett. This is case number 214410901. The people of the state of Michigan versus Rochelle Renee Burnett. The defendant is charged with 1 count of assault or assault and battery, and today is the date set for, what am I looking at for Miss, I mean, what's going on? Mr. Knight, I need you to be still and be ready for court. Mr. Knight is going to have to come in person next time. Today is the day set for the pretrial conference. Appearances, please, on Miss Burnett.
Philip Henderson on behalf of the people, P86029.
May it please the court, Abdullah Mugni here on behalf of Rochelle Burnett, who appears today via Zoom. Rochelle, could you please say your name for the record?
Rochelle Burnett.
Today is the day. Miss Burnett, I apologize. What's your middle name, ma'am?
Renee.
Thank you. Today is the day set for pretrial conference. Mr. Mugni, how are we proceeding?
So, Your Honor, it does not appear that the complaining witness, Shanquise Jacobs, is present here today. That is true. We'd like to move to dismiss based on that failure to appear.
Mr. Henderson.
Yes, Your Honor, we would ask for one adjournment to allow the complaining witness to appear in this case.
Today is the day set for pretrial conference. The court is going to deny defense counsel's motion. It is the first scheduling of the pretrial conference, and the complaining witness, the people have requested an adjournment to locate and notify the complaining witness of the obligation that they appear before the court. I am going to grant that request. The pretrial conference is adjourned to February the 2nd. At 8:36, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, Your Honor.
No, thanks, Your Honor.
All right, then, Ms. Burnett, you're all set until February 2nd, ma'am, at 8:36. Have a great day and stay safe.
Thank you. You as well. Enjoy the
Thank you.
holidays.
Thank you. Happy holidays to you.
Happy holidays. Bye
Thank
now.
you. Bye-bye. Mr. Estrada Jimenez, I'm ready.
I'm here.
All right. This is case number 22-457-4701, the people of the state of Michigan versus, oh, what just happened to it? Oh, DeAndre Knight, defendant is charged with 1 count of larceny. Today is the date set for pretrial conference. Appearances, please.
Henderson on behalf of the people, P86029.
May it please the court, Abdullah Mugni here on behalf of DeAndre Knight, who appears today via Zoom. DeAndre, could you please unmute yourself and say your full name for the record?
DeAndre Deshaun Knight.
And Mr. Estrada Jimenez, can you state your name for the record?
Yeah. Alfredo Estrada Jimenez.
Oh, I think you already said that. I might not have been paying attention. I'm sorry. Today is a day set for pretrial conference. Mr. Mugni, how are we proceeding?
So it seems that the complaining witness has appeared today. So today, Your Honor, we're just going to set this for a final pretrial and request all discovery on the matter.
The court is going to continue a not guilty plea on behalf of Mr. Knight. Set the matter for final pretrial conference, March the 15th. Strike that, March 13th. That's March 13th. At 9 o'clock, discovery should be submitted to the defense by February 13th. Bond will continue with no contact with the complaining witness. Mr. Estrada Jimenez, you have appeared today. Therefore, your appearance is not required on March 13th. However, as the complaining witness, you may appear at all court appearances if you choose to. If you don't appear on March the 13th, you should contact the prosecutor's office or the victim's advocate's office to find out when the next court date is and whether your appearance is required. If it's not a trial, then most likely your appearance is not required unless it's like a bond violation or something like that, okay?
Okay.
All right, anything further for the record?
No, Your Honor.
No, thanks, Your Honor.
Then we're all set, gentlemen. Have a great day, stay safe, and happy holidays.
Thank you. Oh,
and then I might have, maybe I needed to say that Mr. Knight had to come in person, but we'll see. Okay, are we ready on Paul? Are we ready on Paul?
Ready on Paul, Your Honor.
Okay. Is it a plea? Is it a plea?
Yes, Your Honor. Yes,
Oh,
Your
well,
Honor.
hold on. Are we ready on Jarrell? Oh, they're not here anymore. Oh, did I make a mistake and highlight them? I don't see Jeffrey Jarrell. Did I highlight them by mistake?
Mr. Jarrell was on the phone. I don't know if he ever made
Oh,
it
that's
in.
right. He was supposed to come in. Okay, I should have put him in a different color. All right. Are we ready on Hamilton and Jemerson?
Jemerson, we're ready.
Is Hamilton or Jemerson, are those a plea?
No plea for Jemerson.
All right. What about Scalia?
Yeah, I'm ready on Scalia and Hamilton.
Are those pleas?
No.
Okay. Well, you still don't have, do you have on the jacket? Did Ms. Jemerson put on the jacket? Okay, okay. All right. Okay, I'm still struggling a little bit, but okay. This is case number 224500301, the people of the state of Michigan versus Anastasia Jemerson. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
Philip Henderson on behalf of the people, P86029.
Janice Stevenson appearing on behalf of Anastasia Jemerson. Ms. Jemerson, ma'am, please tell the judge your full name.
Anastasia Jemerson.
Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, Ms. Jemerson will continue her plea of not guilty. We're asking that this matter be set for waiver trial.
Court is going to continue a not guilty plea and continue the matter to trial. With respect to the trial, Ms. Jemerson, your lawyer has indicated by her words that you want to give up your right to a jury trial and have the case heard by the court. Is that what you want to do?
That is correct, Your Honor.
Ma'am, do you understand that if I accept a waiver from you today, that you will not have a jury hear the case, but that I would be the only decision maker on the matter?
I understand, Your Honor.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to waive your right to a jury and have me hear the case?
No, Your Honor.
Any objection from the people as to the waiver?
No, Your Honor.
Then finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. And I will set the matter for a waiver trial. My next available waiver trial date is Thursday, February the 1st. At with the 12, let me see.
Judge, any way we can pass on the noon check-in?
Oh, pass on the noon check-in?
Sure.
Wow, when did the people's witness come?
I have it, Your Honor, that the complaining witness appeared on October the 9th, according to our record.
Okay.
I would agree with that.
Okay, then we'll pass on the noon check-in and we will appear for trial at 1:30 on February 1st.
Okay, so if we're gonna still do it, I was just thinking if we're gonna go in the morning, we don't need a noon check-in, but if we're still gonna do late, then.
Well, Ms. Stevenson, why would I do that? What you talking about? I'm not gonna put the trial. I wouldn't put the trial on the docket in the morning because we're not gonna get to it in the morning.
I thought we talked about that at one time, but I think I must be mistaken.
I don't know what you mean.
I thought we talked about if it's going, definitely to try to do it in the morning.
Oh, no, you might have made that up. You might have dreamt about that.
That could be definitely what happened.
I mean, I could give you a different day and we could go in the morning, but I can't give you February 26th. I got February 1st, I have 26 matters.
However, for the court, I'm fine.
Mr. Flanagan, how many do I have on February the 8th?
'26.
How many do I have on? Well, if we're going in the daytime, how many do I have on February 9th? Mr. Henderson, do you have any idea how many witnesses the people have listed for this trial? It's okay if you don't.
Was that, pardon me, was that to me, Your Honor?
Yes, I said, do you have any idea how many witnesses the people have listed for the trial?
Just a second, Your Honor. It appears that it's a one witness case at the most two, Your Honor, if the OIC testifies.
Mr. Flanagan, how many do I have on February 20th?
10.
10. Let's do February 20th at 10:30 for bench trial. All right, anything further?
No, Your Honor.
Nothing on behalf of Mr. Emerson. Thank you, Your Honor.
All right, you're welcome. Ms. Jemerson, we're all set for a trial on February 20th at 10:30 in person.
Thank you, Your Honor.
You're welcome. We'll see you on February 20th. Have a great day, stay safe, and happy holidays to you.
Thank you. Happy holidays to you as well, Your Honor.
Thank you. Mr. Moogny, you said you were ready on which two? Hamilton and
Scalia. Yes,
okay.
ma'am.
All right. Did you all talk to Carter? I don't think you talked to Carter.
No.
Okay. All right, I'm ready on Hamilton. This is case number 234460301, the People versus CcN9Qzzn6c0. Middle name is cut off. It starts with the R.E. Hamilton. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
Philip Henderson on behalf of the people, P860029.
May it please the court, Abdullah Moogny here on behalf of CcN9Qzzn6c0 Hamilton, who appears today via Zoom. CcN9Qzzn6c0, could you please unmute yourself and say your full name for the record?
CcN9Qzzn6c0 Renata Kaniqua Hamilton.
Thank you, ma'am. Today is the date set for final pretrial conference. Ms. Carter, I'm going to send you to a breakout room. Please go to the breakout room and the lawyers will be in to speak with you. All right, as to Ms. Hamilton, today is the date set for a final pretrial conference. Mr. Moogny, how are we proceeding?
So today, Your Honor, we are requesting a date for a jury trial, and any evidence that has not been sent to us, please be forwarded.
Court is going to continue a not guilty plea on behalf of Ms. Hamilton, and I will set the matter for a jury trial. July the 15th. (2024) at 10:30. Ms. Hamilton's case will be the third in priority. I'm going to set a final pretrial conference for June the 18th. We will know if the other two cases are going to go. When is the last time the complaining witness appeared on Ms. Hamilton's case? Oh, it's a 2023 case, so it was this year. All right. Then we're all set until June 17th. Strike that June 18th at 9:10 on Zoom. Anything further?
No, thanks, Your Honor.
No, Your Honor.
Then Ms. Hamilton, you're all set until June 18th at 9:10. Have a great day. Stay safe. Happy holidays to you.
Thank you, you too.
Thank you. Uh-oh, what happened to Mr. Scalia? Okay. All right. Okay, so I have Arnold is a sentencing. Randall is a sentencing. And Paul is a plea. We're gonna take a 5-minute recess so I can refill my cup, and then I'll be ready to go on all of those.
Perfect.
All right. I think we're ready. Mr. Mugni, I think Mr. Scalia is back. Let's see if we can bring him in.
Oh, let's do it.
Mr. Scalia, unmute and state your name for the court. State your name for the court.
Giuseppe Scalia.
Thank you, Mr. Scalia. All right, you can start your video now.
Okay, I got it. Thank you.
All right. Mr. Scalia is back. And where's my docket now? All right,
Giuseppe
this is
Scalia.
case number, this is case number 234512201, the people of the state of Michigan versus Giuseppe Scalia. Defendant is charged with assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
Philip Henderson on behalf of the people, P86029.
May it please the court, Abdullah Mugni here on behalf of Giuseppe Scalia, who appears today via Zoom. Giuseppe, could you please say your full name for the record?
Sir, can you say your name?
Giuseppe Scalia.
Thank you. Can you hear us, Mr. Scalia?
It's everything is like all boggled right now. I'm hearing like 3-4 different times.
You need to log off and log back on, Mr. Scalia.
Yeah, it keeps.
Log off and log back on.
Okay.
I'm ready on Paul. This is case number 234433701, the people of the state of Michigan versus Andre Lewis Paul. Defendant is charged with 1 count of operating with a high BAC, 1 count of operating while intoxicated. Today is the date set for final pretrial conference. Appearances, please.
Philip Henderson on behalf of the people, P86029.
Janice Stevenson appearing on behalf of Mr. Andre Paul. Mr. Paul, sir, please tell the judge your full name.
Andre Lewis Paul.
Thank you, sir. Today is the date set for a final pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Paul and I have had the opportunity to discuss this matter and to review together an advice of rights form. It is my understanding that Mr. Paul wishes to waive his rights incident at trial. He would like to avail himself of the people's earlier offer to plead guilty to count 2, which is 1 count of operating while intoxicated. It is our understanding that people's offer includes dismissal of count 1, operating with a high blood alcohol content.
Mr. Henderson, is that your understanding of the offer?
Yes, Your Honor, that is.
Mr. Paul, you want to accept the people's offer?
Yes, Your Honor.
All right, then, Mr. Paul, I'm going to share my screen. On my screen, it's going to appear an advice of rights form. Mr. Paul, my question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, Your Honor.
Sir, when you did that, did you understand your constitutional rights?
Yes, Your Honor.
Sir, do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept a plea from you today, you will be giving up your right to a trial.
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this voluntary plea today?
No, Your Honor.
Are you currently on probation or parole, Mr. Paul?
No.
Drawing your attention now to number 11 on the advice of rights form. Do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would either have to request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction.
Yes.
With that understanding, Mr. Paul, do you still want to give up your right to a trial and enter into this voluntary plea today?
Yes, Your Honor.
All right, Mr. Paul, raise your right hand for me, please. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down, Ms. Stevenson.
Thank you, Your Honor. Mr. Paul, on May 29th of 2022, were you operating a motor vehicle in the area of westbound I-96 freeway near Grand River Avenue in the city of Detroit?
Yes.
And prior to operating that motor vehicle on that date in that location, had you consumed alcohol?
Yes.
And did the consumption of that alcohol make you intoxicated?
Yes.
Thank you. And for purposes of the plea, we would stipulate that the blood alcohol content was 0.23, and with that, defense is satisfied.
Are the people satisfied, and do the people stipulate to that blood alcohol?
Yes, Your Honor.
All right, then the court will receive the stipulation, and with the stipulation, the court is also satisfied. I will accept a guilty plea to one count of operating while intoxicated, and in exchange for that plea, the court is going to dismiss count one, operating with a high BAC. All right, having accepted that plea, the court is going to set the matter for sentencing February the 16th at 9 o'clock. Mr. Paul, you have a right to be sentenced in person, or you may consent to appearing on Zoom. You are in person today. Which do you prefer?
I'm in person, Your Honor.
All right. Then I'm going to set the sentencing for 9:02, which will denote an in-person sentencing. And prior to sentencing, you must submit to a pre-sentence investigation and substance abuse evaluation through the probation department. Since you are present in the building, if you could please go across the hall to room 317 so that they can schedule that pre-sentence investigation while you're in the building, so they don't have to try to contact you. Anything further with respect to Mr. Paul?
No, Your Honor.
Nothing on behalf of Mr. Paul. Thank you, Your Honor.
All right, and Mr. Paul, you're all set. But officer, can you show him across the hall to 317 so they can schedule their investigation for him?
Yes, Your Honor.
Thank you. All right, we're going to try again. Mr. Scalia, can you hear us?
Yes.
All right. Then we're back on the record with case number 234512201. Giuseppe Scalia. State your name again for the record, Mr. Scalia.
Giuseppe Scalia.
All right. Mr. Mookney, how are we proceeding today?
So today we would like to move for a dismissal based on the complaining witness's failure to appear. And it appears that the complaining witness, well, it appears that the prosecution was supposed to check to see if the complaining witness is still an employee of Tiger Stadium. So that's also a question that we have.
Tiger Stadium. Do Tiger Stadium exist? What's Tiger Stadium?
Oh, sorry, Comerica Park.
Oh, you're not even old enough to know about Tiger Stadium, Mr. Mookney.
I'm not.
Mr. Henderson.
Your Honor, the note that I had did not indicate that I was to inquire as to his employment. He was a security guard at Comerica Park. I did verify his phone number and address and his willingness to go forward in the prosecution. So he is willing to proceed and come to court and testify if it were to go to trial.
So, and I believe you are correct, Mr. Henderson. I didn't require that. He doesn't have to still work at Comerica Park, but exactly the information you gave is the information I wanted. So the people are ready to proceed. Mr. Mookney.
So has he appeared at this point? Because it's my understanding that he failed to appear to the prior pretrials.
He has not appeared, nor has he ever been required to appear. He was acting in his official capacity.
Sure.
Mhm.
Then going forward, we'd like to set this matter for a jury trial and request all discovery that has not been sent over to this point.
All right, and the court is going to set the matter for jury trial July the 15th. At 10:30, with the final pretrial conference, July the 18th. Strike that, that doesn't even make sense. June 18th, I'm sorry. The final pretrial conference is at 9:10. And then Mr. Scalia's case will be the 4th in priority. So that just means, Mr. Scalia, that it may not go July 15th, but it will go next summer. I would just have to move you to a different date. All right. And June 18th for final pretrial conference. All right, anything further?
No, Your Honor.
Well, thanks, Your Honor.
All right, then we're all set until June 18th at 9:10 a.m. Mr. Scalia, have a great day. Stay safe.
Thank you. You as well.
All right, thank you. All right, Miss Stevenson, are we ready? We're ready on the two sentencings.
Ready on Arnold and Randall, Your Honor.
Ms. Arnold, please start your camera. This is case number 214562601, the People versus Joy Brianna Arnold. Defendant is charged with operating while visibly impaired. Today is the date set for sentencing. Appearances, please.
Philip Henderson on behalf of the people, P86029.
Janice Stevenson appearing on behalf of Ms. Joy Arnold. Ms. Arnold, ma'am, please tell the judge your full name.
Joy Brianna Arnold.
Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
No, Your Honor.
On behalf of the defense?
On behalf of Ms. Arnold, Your Honor, we have had the opportunity to review the pre-sentence investigation report. We do offer the following corrections, Your Honor. On page 5, in the other income section, Ms. Arnold does do DoorDash. She makes about $500 a month doing that. Other than that, we don't have any additions, deletions, or corrections. And Ms. Arnold does stand ready for sentencing, Your Honor.
All right, I have a correction, at least one. On page 6, under the mental health, they refer to Ms. Arnold as his current mental state. So we're going to correct that to her. All right, with respect to sentencing, anything on behalf of the defense? I'm sorry, on behalf of the people?
No, Your Honor, we just ask that you accept the sentencing recommendation of the pre-sentence investigation.
Ms. Stevenson?
So, Your Honor, Ms. Arnold, I definitely would say without qualification is ready to move forward from this situation, Your Honor. I am hopeful that this situation is not going to interfere with her nursing career. But I know that she's ready to accept full responsibility for her actions that bring her to court today. She's thankful to be alive and around, and it is just really, especially considering some of the things that she unfortunately had to experience in her childhood, Your Honor. I don't think that she's interested in a life of substance abuse or anything like that. She just wants to move forward and is hopeful that this will not hold her back.
Would Ms. Arnold like to make a statement on her own behalf?
Yes, Your Honor. First, I'm very grateful for your courthouse. I'm grateful for you. I'm grateful for my representation and Attorney Stevenson. I've never had any prior experience in a courtroom, so I know we've had some bumpy encounters, so I'm grateful for your patience. Secondly, I would like to acknowledge that I'm just deeply remorseful about the actions that I engaged in that landed me at the mercy of the courthouse. I'm very aware that it wasn't just my life that was put in jeopardy, but plenty of innocent people on the road, children, namely, which I'm very passionate about. So I am grateful, of course, as Ms. Stevenson stated, that no one else was harmed. But I also plan to move forward in full accountability by abiding by the laws in place for our safety, honestly, which is something that I've been able to really have time to process and think about throughout this court case. So I don't plan to move forward drinking and driving, operating while visibly impaired, or anything of the likes moving forward. And again, I'm just very grateful to the courthouse for you guys' patience. Thank you.
Okay. That was a really nice statement, and it would have meant more to me. So it was a good statement. It was a good addressing to the court, addressing the court. But it would have been even better if I didn't turn on page 6 and see that Ms. Arnold tested positive for alcohol and marijuana. So all of those statements would have been just so wonderful, except that she tested on November the 30th, and she tested positive for alcohol and, I'm sorry, she was negative for alcohol.
Thank you, Judge.
She was negative for alcohol. She tested positive for marijuana. And then, but this is what I'm saying right here. So she was negative for alcohol on the day she tested. But it says defendant admitted last day of use for alcohol and marijuana was Thanksgiving. So then she self-reported the use of alcohol. We know she used marijuana, right? Because she tested. So that's confusing to me. And then let me tell you what it also says to me. So Ms. Stevenson, you are aware, but this is how I feel about people who drink after they've been ordered not to. Then I say they have a problem, because if I say don't drink and you don't, well, I apologize. I believe it's one of two things. One of two things. So either they have a problem or they don't care about the court's orders. So if I say don't drink and you don't have a problem, you don't drink. But if I say don't drink and you do have a problem, then you're gonna drink. You might drink because you can't, you have a problem. Or if I say don't drink and you don't have a problem, but you drink anyway, that says, well, I'm gonna do what I want to do no matter what you say. And either one of those things have to be addressed by me, because it would make no sense for me to show up and they make you wear this black robe. And I hope they never prohibit us from at least putting on the jewelry. And then you come here, you have on the robe. That don't make sense for me to show up as a judge if I just say, well, defendants, what do you want to do? And then they just tell me what they want to do. So that was a real nice speech, but your actions aren't necessarily lining up with, I want to make sure that I do what I need to do for the probation. I don't care that it was Thanksgiving. I don't care what the circumstance was. I don't care what the holiday was. I don't care what the celebration was. I don't care what the event was. If I said don't drink, I meant it when I said don't drink. I meant it. Like I meant it when I said no drinking and no driving without a valid license. I meant it when I said it, right? I also noticed that she has a restricted license, and I don't care what she, does to get money as long as it's legal. And then as long as whatever she's doing, the driving that she's doing are within the restrictions of her restricted license. All right, so I'm going to go ahead and sentence Ms. Arnold, but it's going to be a little bit stricter than it would have been had she not been drinking and smoking weed. I was trying to look and see, go back and see, did this say anything about I don't see it on here. Oh, but I did want to also address of how much she was smoking. That's just too much to be. So I don't even know. I mean, I guess a person who don't want anything altering my state, my natural state of being, I don't understand how people can smoke this much. But also, if you're trying to be a nurse, I don't want you working on my loved one high and smoking. I don't want, if I'm in the hospital, I don't want nobody coming in high. I don't want nobody coming in smoking, who's smoking weed. I don't want it. And I hope that they would ban people in the medical profession from smoking weed, and that they will regularly do drug tests on the people who working on people who sick and can't help themselves when they're in the hospital. We depending on the people who taking care of us not to be high. Some people shouldn't be allowed to smoke weed, period. The pilots, doctors, nurses, some people shouldn't be allowed, but I'm not in charge of all of that. All right. There is a recommendation for 12 months probation. I'm going to accept the recommendation for 12 months probation. That puts a final review date of December 2024, and I'm sorry, yes, 2024, and the date would be December the 12th, 2024. Court is going to set a review March the 12th, 2024 at 10 a.m. The court is going to set the following conditions of the probation. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of the court. You must make a truthful report to probation on a monthly basis, and you must notify probation immediately of any change of your address, phone number, or employment status. You must pay the following fines, costs, and fees: $210 mandatory costs, $100 attorney's fee, $350 fine, no restitution, $420 oversight fees at a rate of $35 per month, $100.
We have that reduced, Judge.
She can afford to smoke weed. She can afford to pay.
Okay, so she's in school full time.
She can afford to smoke weed. She can afford to pay.
Understood, Your Honor.
Okay. Court is going to also order urinalysis. I would have ordered twice a month, but I'm gonna order 3 times a month to start. So 3 times a month, and then it can be reduced to 2 times a month after the first review if I'm satisfied with the results. So that's going to be well, let's do it like this. $270 for the urinalysis. So the total fines, costs, and fees are $1,450. Of course, you have the duration of the probation to pay that amount. You shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume any alcohol in any form. You shall not drive without a valid driver's license. You shall attend the Alcohol Highway Safety Education Level 1. You shall attend the Victims Impact Panel and watch the consequences video. If any positive tests, you shall attend outpatient treatment. You shall attend the Driver's Improvement Program. All right. And if you have any tickets at the 36th District Court, which according to the report, you owe $738, you must pay that in full or get on an approved payment plan. If you have any outstanding warrants, you need to clear those up. And we will come back for review March the 12th. We are going to mail a copy of this order to the West Jeffries address, and probation will contact you at the phone number ending in 6494. Anything further?
No, Your Honor.
Nothing on behalf of Ms. Arnold, Your Honor. I would want to say I believe that Ms. Arnold has heard the court, Your Honor. I think she's gonna show you better than she can tell you by that first review date. I really think so.
Well, that's going to be great. I love it. I love to be proven wrong when I don't think somebody's going to do something. All right. Well, when I don't think somebody's going to do something positive, I want to be proven wrong. I mean, I want to be proven right if I don't think they're going to do something negative. But anyway, okay, then we're all set with respect to Ms. Arnold. Ma'am, you have a great day and stay safe. I'm ready on Randall.
Ready on Randall, Your Honor.
Ms. Randall, please start your video, ma'am. All right, this is case number 234435001, the People versus Kaylin Page Randall. Defendant is charged with operating while intoxicated. Today is the date set for sentencing. Appearances, please.
Philip Henderson on behalf of the People, P86029.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Kaylin Randall. Ms. Randall, ma'am, please unmute and say your full name.
Kaylin Page Randall.
Today is the date set for sentencing. Court has had an opportunity to review the pre-sentence report With respect to the report, are there any additions, deletions, or corrections on behalf of the people,
No, Your Honor.
on behalf of the defense?
On behalf of Ms. Randall, Your Honor, I have forwarded an address as well as telephone number correction to Mr. Clerk on behalf of Ms. Randall. The address listed on the face sheet as well as the telephone number are both incorrect completely. She's never provided that information to the probation department. So I did send over the right information. That's just completely wrong, and she doesn't know why. In addition, Your Honor, so on page 4, while I know that I cannot comment substantively on the police description of the offense, I do want the court to know that that first line indicates that the report dated July 4th of 2022, but then that paragraph starts with on July 31st of 2020. So we believe the incident date that brings us to the court was actually July 4th of 2022.
Okay.
On page 5 in the employment section, the interview that's listed there had some positive results, and Ms. Randall is scheduled to start with that company in January of 2024. In the education section, under college/advanced degrees, it indicates that she'll be starting a school called Dental School in fall of 2024. That's actually should be Dorsey Schools. On page 6, in the substance abuse use and treatment section, I don't know if it's a correction, but at least a clarification. We want the court to know that, and we'll speak to this at our time, but Ms. Randall did submit to your analysis yesterday. Other than that, we have no additions, deletions, or corrections, and Ms. Randall does stand ready for sentencing.
You don't want to tell me why she failed to appear on 12/1 and why she couldn't tell? Oh, this deletions and corrections. That's my fault. That's okay.
Oh, okay. Okay.
No, that's my fault. Mr. Henderson, anything on behalf of the people?
Your Honor, just to say that we believe that correction with regard to the date is correct. It was July the 4th. So we accept that as factually correct.
Well, July 4th, 2022.
Right.
Right. Not, okay. Yeah. All right. Thank you. Anything else on behalf of the people?
No, Your Honor.
All right. Ms. Stevenson? Yes,
Your Honor. So with regard to the information that's the prior criminal history, we want the court to clearly understand that the probation from the incident dated April 21st of 2022 was completed, that because of this case, she suffered a sanction, I think pretty close to the beginning of the probation, and did have to spend 30 days in a halfway house / treatment facility. So I want the court to see that, I don't know that I would call these two cases contemporaneous, but they're pretty close in time to each other. So, so Ms. Randall was really just at the beginning of, whatever rehabilitation would be available to her under that first case at the time that this case happened. And I do think that that's significant. It's not that she gets all the way through or almost all the way through or even halfway through a probation and then picks up another case. I think that there were some substance abuse issues that Ms. Randall has been able to get on top of. With regard to the testing situation, so Ms. Randall explained to me that after she left her meeting with the probation department for the pre-sentence investigation on November 28th, that it was brought to her attention that she should have tested, or she was contacted and asked whether or not she tested. And she's advised me that she was not informed that she should have tested on November 28th of 2023.
So there's a difference, and I'm gonna call probation. If you're saying that they didn't ask her to, there is a difference.
Yes, I agree with that.
Okay, well then, Mr. Flanagan, let's get Ms. Lurst. Let's get Ms. Lurst.
Yes, Your Honor.
Okay, go ahead.
Thank you, Your Honor. That probation did contact Ms. Randall, and based upon her not testing when she was at the courthouse on November 28th, during the time of that interview, she was asked when she could come in. To be forthright, Ms. Randall advises me that she told Ms. Lurst that she could come in on December 1st, and then she didn't make it on December 1st due to some issues that really don't even matter so much right now, Judge. But she did test yesterday. And we want the court to know that I have done my very best to impress upon Ms. Randall how central your analysis is to whatever order would come forth from this court. That is not something that, we kind of fit in if we're on probation, that your analysis is something that has to be scheduled around. Ms. Randall expressed to me that she does understand that at this point. I don't know what the results are going to be. She's indicated to me she believes that they would be negative, but there's no reason for the results to be positive for alcohol.
Well, when you get to pick the day that you come in, of course, it's no reason for it to be positive when you get to pick your day.
I understand that, Your Honor, completely. And I think that Ms. Randall understands that as well. So I am hopeful. I don't see this as a situation where I hope that the court would not be considering any jail time for Ms. Randall. I hope that the court would give her an opportunity to show that she would be able to lean into into a probation and demonstrate that she, in fact, already has been rehabilitated by that first probation, Your Honor. We would hope that she wouldn't have to engage in any duplicative sentencing, Your Honor, but I think that Ms. Randall understands, or we've had, done my best to explain to Ms. Randall that whatever the cause, whatever the situation, this part of her life will just go easier if she's able to just take the bull by the horns and accept full responsibility for whatever decisions that she made to bring her to this place at this time. And that she'll just lean into it. I think she did the victims impact panel through the first probation, Your Honor. And again, those two instances are really close in time to one another. She did alcohol highway safety education level 1 through ETRS. So, Ms. Randall just wants to go forward, Your Honor.
All right. Good morning, Ms. Lurst.
Good morning, Your Honor.
Ms. Lurst, I don't know if they told you I've asked you to come with respect to Kaylin Randall.
Yes, Your Honor.
Okay, you prepared the pre-sentence investigation for Ms. Randall, and specifically the court wants you to address something that you wrote on page 6 under the substance abuse use and treatment in your notes, the comments underneath.
Yes, ma'am.
Okay. So when you said on there, the defendant was unable to test on November 28th, 2023, and was to return on December 1st. What did you mean by that?
Your Honor, when we met on that day, we were supposed to go down and test, and I was unable to take her down there on that day. So I called her and asked her to come back in the next day to test. And we made arrangements for her to come back on the 1st, and she didn't come in on the 1st. So
Okay. But so on the 28th, though, when you write on the 28th that she wasn't able to test, that was not her fault. That was
No.
a situation with your scheduling.
Yes, Your Honor.
Okay, great. That's what I needed to know and clarify. And then, okay, yes, okay.
I'm sorry, Your Honor. She did come in and test yesterday. I was not here. I was out, and she was negative for all substances.
Yeah, if I picked my day and came 13 days later, I would be negative too. But okay.
Understood, Your Honor.
Yes, thank you, Ms. Lurstow. That clarified the other issue. So that's all I needed. Thank you so much.
Thank you. Have a good day.
All right, you as well. Okay, so then with respect to that issue, as it relates to November 28th, I'm satisfied. Okay, would Ms. Randall like to make a statement on her own behalf?
Yes.
You may. Oh, and did I correct this precinct's report? On page 6, I didn't. They did the same thing with Ms. Randall, and I'm sorry. Before she makes her statement, under the comments on page 6, down at the bottom, they said his instead of her. So we want to make that correction.
Thank you, Your Honor.
All right, you're welcome. Okay, Ms. Randall.
I would just like to say that I take full accountability for my actions. I do understand that drinking and driving is dangerous, and it's my fault that I'm in the current situation. This past year, I did have time to reflect on my mistakes, and it'll never happen again.
Okay. All right. So I have read the precinct's report as you can see. I will say, again, I'm always, I don't know. I guess no age is a good age to engage in reckless behavior. So I don't know. I just feel like sometimes though, if a person is much older, I feel like they should have more wisdom by the time they get there. I do understand that, a person in their 20s still trying to, figure it out and all of those things. I am disappointed in the 2 drunk driving cases and the close in time for them. But again, I guess that shows more, that could show more of a season of, I'm engaging in this reckless behavior. I did it. It was wrong, but it's not something that lingered on. So I will acknowledge that. But it is so very dangerous, right? It is so very dangerous. I don't know. Again, I was so appalled and taken aback today to learn that the gambling disassociated person cases are 1-year misdemeanors. That threw me off my whole entire square, because that also says to me that the legislature thinks that it's more serious to gamble as a disassociated person than it is to drink and drive and put everybody's life in danger. That doesn't even make good sense. But I'm not in the legislature. So again, I don't get to determine the maximum penalties for different things. Clearly, drinking and driving should be at least a 1-year misdemeanor then, if they've put gambling as a 1-year misdemeanor. Because it's so dangerous, Ms. Randall. It's so dangerous. It is one of the most dangerous and irresponsible things that human beings do. And unfortunately, the reason that we have Mothers Against Drunk Driving, and I think it's a MAD and a SAD. What do the S stand for? Siblings?
Students, I think.
Oh yeah, students. Yeah. We have mad and we have sad. I don't know if we have dad, but seem like we should have a dad too, because dads should be against drunk driving too. It's because people die at high rates. And one of the things that I hate about the whole thing, Miss Randall, and sometimes people don't die, which depending on the person, that could be worse for them in terms of how they think, because now they live and they're quadriplegics and they're this, and sometimes they don't even have support. They have nobody to help them, to take care of them, right? And one of the things that bothers me, and when I make these type of speeches, I always want the person to know I've never been the victim of a drunk driver. Neither have anyone in my family. I've never suffered a loss. I'm thankful and grateful that my children have never been, involved in the situation of drunk driving, none of that. So my opinion and my position has nothing to do with any personal experience that I have. But I see other people grieve the loss of their children. I see people grieve the loss of their husbands and wives. I saw a case on TV recently where a couple got married. A couple literally got married at the beach, and there was a golf course right across from where they got married, and the bride literally got ran over by a drunk driver after they just got married. How awful. How awful was that? Right? So I'm saying that to just say, Miss Randall, there's no crime to drink. Drinking is not a crime. Drinking is legal. But it is irresponsible when people get in a vehicle. That vehicle becomes a weapon, which is why I don't understand why the legislature downplays it for a 93-day misdemeanor. But that vehicle becomes a weapon, and it can destroy anything in its path. And a lot of times, the person that is yielding that weapon, the driver, they usually survive. And the innocent person is the one that usually is harmed. You have 2 drunk drivings under your belt. I hate that for you at your age. I really do. I hate that for you. I'm thankful that you're still able to be in my courtroom, though, on a misdemeanor. I'm thankful that you're still here on the misdemeanor. But I don't know if anybody informed you. If you get another one, now you're going to go up to the felony docket. Three times is a felony. Miss Randall, I believe that you're a smart young lady. You're so pretty and smart, and just think about that, how your parents would feel if a drunk driver hit you and now they have to take care of you for the rest of your life. Right? So just make better choices. Make better choices. If you know you're going to be drinking, just, while you're sober, this is what I tell people to do. Make decisions while you're sober for your intoxicated self. If you know you're going out to drink, make the decision while you're sober. Who's going to, that's why they say designated drivers. Who's going to take me home? If I'm by myself at this function, set an alarm on my phone so that the people with me can say, are you sober enough to drive? Like, set an alarm, check my sobriety, right? So that now somebody with me is going to say, oh, girl, your phone saying check your sobriety, honey, you can't drive. Where your keys? An accountability partner. The bartender at the thing. If your alarm going off and it's saying check your sobriety, that should alert the bartender. Because I'm not suggesting that there are not things that happen in our lives and people turn to certain things. Some people turn to alcohol, or some people just drinking to have a good time. And you don't realize that you need to check your sobriety. So I'm thankful that both times that you picked up these drunk driving cases, that they did not result in harm to you or harm to another person. I am going to accept the recommendation for 18-month probation. I'm going to set the terms and conditions as if she didn't do the other probation. And then if she has completed a term and condition of this probation already within, you know, I'll look at the paperwork and see the time frame that she completed the conditions, then I may accept them. So for example, Ms. Stevenson, you said she viewed the victims impact panel. Then I'll look and see, well, when did she view the victims impact panel? Yes, she doesn't have to view it again. I'll accept, you know, that she viewed it the first time. So if something overlaps is what I'm saying. The court is going to accept the recommendation for the 18-month probation. You will be eligible for early discharge according to the legislative rules after 9 months. The 18-month date is June 12th. I'm going to set it for June 12th for the 18-month date of 2025. And then half of that you'll be eligible for discharge, but I'm going to bring you in for review in April to see where you are and how you're doing. Also, because I'm probably going to give you a greater testing to start out with. Oh, well, she said that test was negative, but I'm not happy about that. Let me say this to you also, Ms. Randall, and I don't know what the lawyer has already said to you, but this is how I feel about drug tests. A drug test that is anything other than random is not a drug test to me, and I don't want to see it. If you have an appointment to get a drug test, that's not random. You have time to prepare for that drug test, especially on an alcohol case where alcohol doesn't stay in your system as long as marijuana, as long as other drugs. It is very important that you go, that you test on the day that you're asked to test, and at the time that you're asked to test. If they tell you to come on Monday and you show up on Tuesday, you keep your money. This is what I'm telling people. It's as if you didn't test. In my eyes, I don't care what the results say. So while I guess Ms. Stevenson wants me to look positively, I guess, at the fact that you showed up yesterday, that test means absolutely nothing to me. It is literally almost 2 weeks from the date they told you to test. I don't care what your results were on that day. I literally don't. I wanted to test on the 30th, but she at the latest on the 1st. So she said she couldn't take you on the 30th, and so she told you to come on the 1st. I would have accepted the results on the 1st since it was her fault. Like, she didn't take you. Not the results on the 12th. I'm not even interested. So it is important that you go on the day or that you're ordered to go, so that I can get those tests. I wrote down 4 times a month when I thought you had just not tested on the 30th. So I am going to change it. And I'm going to go ahead and give you a chance. I'm going to do the regular twice a month. But it's only the day that they tell you to go. Literally, if your probation officer says, okay, well, you come tomorrow, say, nah, the judge told me don't waste my money because she don't care about the results. You know, unless there's, it has to be like a valid, legitimate reason. Like, judge, they told me to come, but I was in the hospital, or, you know, something valid that I would accept. I'm going to set the first review, if I didn't already give the date, because I didn't write it down, for April. I want to set it for April let's go. Oh, let me check my schedule. April the 18th, but let me see. Yes, April 18th at 1:30. That'll be your first review. All right. With the following conditions, you shall not violate any criminal law of any governmental unit, must not leave the state without consent of the court. You must make a truthful report to probation on a monthly basis, and you must notify probation immediately of any change of your address, phone number, or employment status you will pay the following fines, costs, and fees: $100 attorney's fee, $500 fine, no restitution, supervision fees. For 18 months, it will be, I should know it, but $630. Now, if you get discharged after 9 months, then of that 630, you only have to pay 315 of that amount. So we'll prorate it if you get discharged early. So let's say if you're going to pay off your fines and costs before that halfway review, you can pay everything except $315. If there's a balance of $315 and a balance with the drug test, then I'll waive it because that would have been something in the future. Court imposes a $100 assessment fee, and at twice a month for the drug test. Whoops. So that's $20 a month times 18. So the drug tests are $360. But if I decrease the drug test or you get discharged early, again, that also will be prorated. But your total for an 18-month probation is $1,900. Also, if you're unable to pay that, all of it except $210 can potentially be converted to community service. But we'll address that at the first review. You shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor as to why you need an opiate. You shall not consume any alcohol in any form. You shall not drive without a valid license. According to this report, Ms. Randall, your license is suspended, and I have nothing to do with getting it unsuspended. You have to talk to the Secretary of State about how to get your license unsuspended. And then because you're not in the drug treatment court, I can't do any, like there's no special program for me to get your license unsuspended. You're gonna attend the Victims Impact Panel, and I will accept proof that you've already done that and make a decision if you have to do it again. Watch the consequences video. You're gonna attend outpatient treatment if positive. If any positive test, you're going to complete the driver's improvement program. According to this report, with respect to tickets, it says you don't have any, zero balance, but I'm gonna still just order that you pay any tickets if there are any. It did say that you graduated with your diploma, but I do want you to, it doesn't say that it was verified, so I'm gonna say that you have to verify your proof of education. And I'm gonna hold off. I had also checked the box for the choices program, but I'm gonna hold that off in the base to see how you do. If you do well and it looks like you are making better choices, then I won't send you to the choices program. We are gonna mail a copy of this report. And Ms. Stevenson, if you don't mind, because I mean, can you send an email to me and Mr. Farmer, just indicating or question, like, where did this address come from? You saying this is not even close to her address or phone number?
Correct, Your Honor.
That's really not good, but can you just bring it to our attention in an email?
Yes, yes, Your Honor.
Okay. All right, so we'll get the correct address and phone number, and then we will mail a copy of the court's order to that corrected address, and then probation will contact you at the correct phone number. All right, anything further?
No.
I have nothing on behalf of Ms. Randall, Your Honor. Thank you very much.
Nothing from the people, Your Honor.
All right, then, Ms. Randall, I'm looking forward to you showing me that you have you know, that those were just two very bad decisions, okay?
Okay, thank
All
you.
right. You're welcome. Have a great day. Stay safe.
You too.
All right. Miss Carter, can you turn on your camera?
Yes. Good morning.
Good morning. Why are you leaned over like that? Is it? Do you have on a hat, Miss Carter?
Yeah, I had on a hat. Can you hear me?
I mean, Miss Stevenson, what am I supposed to do right here?
Miss Carter, if you could please turn off the music or whatever in the background, and please remove your hat, ma'am, for court.
I took the hat off already. I'll
Okay.
tell the roommate to turn the music down. Give me
Thank
one
you.
second. He turned it down.
I'm gonna reschedule the matter, Miss Stevenson.
Understood, Your Honor.
Okay.
Sounds
Okay.
like it's off now, Judge.
Oh, okay. Okay. All right. This is case number 215661901, the People versus Aaron Lynn Carter. Defendant is charged with 1 count of weapons, purchasing without a license, and today is the date set for review. Ms. Stevenson, your appearance, please.
Janice Stevenson appearing on behalf of Ms. Erin Carter. Ms. Carter, ma'am, please say your full name.
Aaron Lynn Carter.
All right, today's the day set for review. I do have a report from probation, and I just want to state, I don't know, for the record, I think it's just interesting that probation will tell me that they can't supervise a case. And so that's just was funny to me when I saw that it says the probation will no longer be able to supervise because they reached their maximum. And I'm gonna send an email about this, but don't worry. So today's the day set for review. She has completed the main terms and conditions of her probation according to the probation department, but she still has a warrant out of Bloomfield Hills. And it does say traffic. It does say that it's a traffic warrant. So, Ms. Stevenson.
Your Honor, despite the fact that that matter has not yet been resolved, I would ask the court to close the matter at this time and make the court aware of the fact that Ms. Carter is going to go through her graduation tomorrow, Your Honor. So she's recently finished school and does not have a job yet. She's put in a lot of job applications, and the fact that this case has not yet been resolved may be interfering with her ability to get to work. She has to pay $1,000 to resolve that matter in the 48th District Court. So I'd ask the court to close the matter at this time, Your Honor.
Okay, well, where are you graduating from, Ms. Carter?
Focused Hope. I did CNC and welding, the welding program.
Oh, great. Oh, okay. Oh, that's great. Well, congratulations on that.
Thank you.
All right, so I am going to close the matter out. And I'll even just still close it with improvement as a graduation present. And then you're welcome. And then you'll know, I mean, you need to know though that you do have that warrant. So I don't know, you know, what Bloomfield Hills does with respect to your traffic warrants, So just know that that's out there. So I'm going to close Ms. Carter out with improvement. And we'll send you a copy of that closure, okay?
Thank you.
You're welcome. Have a great day. Stay safe. Happy holidays.
Happy holidays.
Thank you.
Bye.